What does full coverage mean for a person who's been involved in a car wreck in the state of Tennessee? Hi, I'm John Griffith. I'm a personal injury trial lawyer practicing law in the state of Tennessee. Every week I get calls from people who, like you, have been involved in a car wreck. When I ask them about their insurance coverage, they tell me they've got, quote, full coverage. Well, what does that mean? Tennessee law does not define what full coverage means. Most people, to have full coverage means that they have collision coverage for their car. What is collision coverage? Collision coverage means damage to your car only. Your car is protected if it's hit by someone else, or if you back it into a wall or run into a tree. Your car will be covered up to the actual cash value of the car immediately before it was damaged. Tennessee law requires every driver to have insurance. Everyone is required to have liability insurance. What does that mean? Liability coverage is coverage for harm you might do to others as a result of driving your car. Your liability coverage will also pay all of your defense lawyer costs. You do not have to pay for that charge. Liability coverage mostly covers people for negligence while they're driving. However, it does not cover you for everything that you might do while behind the wheel. For example, drinking and driving, driving under the influence of drugs. Those are actions that might be deemed punitive damages for which your liability policy would not pay for. Another form of coverage you can get on your car insurance is called medical payments coverage, or MedPay for short. Medical payments coverage covers medical expenses that may be incurred by you or other occupants of your vehicle if you've been involved in a wreck. Usually it's only covered up to a very small amount, usually $1,000, $2,000, or $5,000. The last coverage I want to talk to you about today is something very important called uninsured motorist coverage. It's also referred to as underinsured motorist coverage. Uninsured motorist coverage covers you for every loss that you might sustain caused by another vehicle who either does not have any insurance or, more commonly, does not have enough insurance. Let me give you an example. If you were hit by someone who has full coverage but they've only got the minimum state requirements of $25,000 of coverage, your uninsured motorist may turn into underinsured motorist and pay the excess amount of your harms up to your limits of coverage that's not covered by the liability carrier. One of the biggest mistakes I see all of my clients make is they trust their own insurance company. This can be a very bad mistake. If you turn in a loss that's caused by another person, your insurance adjuster knows that that person that caused the harm to you, even though the other person's at fault and it should be covered under their liability coverage, your adjuster knows that that person may have no insurance, or if you are severely hurt, that other person may not have enough insurance. In the event that that other person does not have enough insurance, then your own insurance company will be responsible for the deficit in paying for all of your harms and losses, capped at the amount of liability coverage you choose under your uninsured motorist coverage. So for that reason, it's very important to have very high limits of uninsured motorist coverage covering yourself and protecting you and your family. People are often shocked to later find out that their own insurance company has hired a lawyer to defend the person that hit you and to pay you as little money as possible or try to totally defeat your case. Never, ever, ever trust your own insurance company. They are not out for your best interests. If you have questions about your case, call me. I'm here to help. I can be reached at 615-807-7900 or email me at john@griffithinjurylaw.com.